Hello, my name is Tom McNamara. The topic of today's program is a music industry's game of monopoly featuring the Department of Justice, DOJ, the American Society of Composers, Authors, and Publishers, ASCAP, and Broadcast Music, Inc. I'm currently an associate at Ropers, Majeski, Cohen & Bentley, where I practice business and commercial litigation, as well as entertainment law, with a particular focus on music industry transactions. None of the views I express are the views of my current or any former employers, and I am speaking solely for myself as part of the CLE program. Now, today's hot topic is very timely, unless, of course, you are watching this in virtual reality in the year 2040. As I speak, the DOJ, ASCAP, and BMI are battling it out over consent decrees, fractional licensing versus 100% licensing, and related embedded issues. Notably, the DOJ seeks to replace the fractional licensing that has been the industry norm for more than 75 years with a methodology favored by radio stations, streaming services, and other third-party licensees, that anyone with an interest in a song can license it on behalf of the other owners, so-called 100% licensing. The industry remains very concerned with this new DOJ interpretation of ASCAP and BMI's consent decrees that outlaws fractional licensing, in effect saying only one party will have the right to administer a song, and only one party can collect. Now, the battle reared its head a few years ago when ASCAP and BMI urged the DOJ to tear apart the antiquated consent decrees, which, ironically, were established decades ago so that ASCAP and BMI could offer the kind of blanket licenses that they do today. Now, under the consent decree provisions, ASCAP and BMI must offer licenses to services and venues on equivalent terms. Instead of modifying consent decrees, which ASCAP and BMI originally requested from the DOJ, the battle has spawned into one over fractional versus 100% licensing. Now, because the distribution and consumption of music is way ahead of the regulation and laws of the music industry, the ongoing battle I just mentioned was really inevitable. The fascinating part of this topic is that it involves an intersection of intellectual property law, constitutional law, and economics on the highway of the music industry. So to quote the late great Tom Petty, everyone in the music industry is just running down a dream. But the DOJ, ASCAP, BMI, publishers, and singers and songwriters are not all running in the same direction. So to understand today's game of monopoly in the music industry, we need to go back in time to understand how the rules were promulgated and how each player landed on the monopoly board. We will navigate through such topics as copyright law, the history of consent decrees, the formation of performing rights organizations, record label agreements, publishing agreements, and constitutional law arguments associated with the DOJ's current position. I will then provide some specific examples of songwriter royalties at the end of the program so we can tie this whole thing together. So, here we go. Back in 1909, Congress passed a Copyright Act that led to the emergence of collection societies, also known as performing rights organizations. The Copyright Act of 1909 created two very important rights. One, the mechanical reproduction right, and two, the right of public performance. The Harry Fox office was established by the Music Publishers Protective Association soon after the 1909 Copyright Act to collect the 2-cent mechanical fees owed to composers for records. So don't you worry, I will dive much deeper into mechanical fees and the current statutory rate later in this program. Believe it or not, the United States extended no copyright protection to sound recordings until February 15, 1972. Between the adoption of the Copyright Act of 1909 and the 1971 Sound Recording Amendments, only musical compositions submitted to the Register of Copyrights in the form of sheet music were protected by federal copyright. The individual oral representation captured for playback on a cylinder, disc, or tape could only be protected by the common or statutory laws of the individual states. The 1971 Sound Recording Act amendments specified that only future sound recordings were subject to federal protection. This feature was carried forward into the comprehensive revision of the Copyright Act, enacted in 1976 and implemented on January 1st, 1978. So although Section 302 of the Copyright Act contained a sweeping provision that brought works created prior to 1976 legislation under federal protection, pre-1972 sound recordings were specifically exempted by Section 301C. So I bring this up at the outset because many of the proposed solutions, such as the Fair Play, Fair Pay Act, to today's problems in the music industry attempt to close that pre-1972 sound recording loophole. In fact, SiriusXM recently settled a class action lawsuit filed by musical duo Flo and Eddie about their pre-1972 recordings. I will explain that case in its appropriate context later in this program. Again, don't worry, we will also discuss even more about the Fair Play, Fair Pay Act, and I will examine mechanical reproduction rights later in this program. So on to the second right created by the Copyright Act of 1909, the right of public performance. This is really the subject of today's program. The right of public performance ultimately led to the creation of ASCAP in 1914 because copyright owners seeking to enforce public performance rights were unable to detect infringing activity independently. I implore you to read the Supreme Court's analysis in the 1979 decision rendered in the case of Broadcast Music Inc. versus CBS Inc. So this begs the question, how does ASCAP operate? ASCAP collects a single fee from licensees that ASCAP then divides amongst its members based on a complex pro rata formula after monitoring the songs played. I urge you to read the Southern District of New York's more detailed explanation in the 1960 decision rendered in the case of United States versus ASCAP. With ASCAP's anti-competitive monopolistic power over public performance rights, broadcasters formed a second PRO in 1939, BMI, which served as a broadcaster-friendly alternative to ASCAP. Again, you can read more analysis by the Supreme Court in the same 1979 case of Broadcast Music Inc. versus CBS Inc. However, the emergence and power of ASCAP and BMI led to the DOJ's antitrust actions today, which, unbeknownst to the music industry at the time, sowed the seeds for the game of monopoly that is still in existence today. So let's take a quick break to examine what a consent decree is in the general sense and the history of it. The first consent decree was entered in 1906 in the case of United States versus Otis Elevator Company. The Department of Justice has disposed of civil antitrust suits through settlement negotiations followed by entry of a consent decree. Since its first use, the consent decree has become entrenched as the most powerful and potent tool and often used tool available to the federal government. While no statute expressly authorizes the government to employ the consent decree as a means of terminating civil antitrust litigation, the Supreme Court has affirmed the power of the Attorney General to agree to a valid consent decree. Although the terms of the proposed consent decree are negotiated between the Antitrust Division of the Department of Justice and the defendant, the actual entry of the decree, and thus its final acceptance, is really a judicial act. Since a decree, once entered, is a judgment, it has the same legal effect as a judgment entered following a fully litigated action. The degree to which a court ought to scrutinize the proposed decree before its entry has become a true matter of controversy. The courts themselves have been unable to agree on a proper standard for review, and much of the guidance provided by the Supreme Court consists of dicta in cases in which third parties were denied intervener status to contest entry of the decree. So, in an effort to provide a procedural structure for the consent decree process, Congress enacted the Antitrust Procedures and Penalties Act, the APPA, in 1974. In doing so, Congress expressly provided that before a district court enters a proposed consent decree, it must determine that the decree is in the public interest. To assist the courts in their efforts to make this public interest determination, Congress identified several factors that the courts, in their discretion, could consider. However, neither the statute nor the legislative history provides a clear indication of the standard by which the courts are to assess the public interest. The power and duty to enforce the antitrust laws are vested in the Attorney General. Inherent in this enforcement is a substantial degree of discretion required if the Attorney General, through the Antitrust Division of the Department of Justice, is to implement the antitrust enforcement policies of the executive branch. The division must decide not only which cases to initiate, but which should be litigated and which should be settled to achieve the optimal antitrust enforcement, particularly given the limited resources of the division. Now, since the 1928 case Swift and Company versus United States, the Supreme Court has recognized that the discretion of the Attorney General is necessarily broad. This broad power vested by the Attorney General as regard consent decrees is something to really keep in mind as we move through today's program. With the state of today's streaming music industry and the antiquated consent decrees in the way, the music industry is really stuck in monopoly jail until someone pulls a chance card. Now, I'd like to return back to ASCAP and BMI. In 1941, ASCAP and BMI entered in antitrust consent decrees with the DOJ to safeguard their monopoly and regulate their operation as not-for-profit PROs. Notably, fellow PROs, Global Music Rights, GMR, and the Society of European Stage Authors and Composers, CSAC, are not bound by the consent decrees because they are for-profit entities. So I will discuss more about CSAC and GMR later in this program, so stay tuned. With respect to ASCAP, the consent decree includes requirements that ASCAP 1. Offer licenses other than a blanket license, 2. Hold any non-exclusive licenses, 3. Issue a license to any applicant that meets certain requirements, 4. Permit any composer with a copyrightable music work to join ASCAP, and 5. Negotiate voluntary rates and terms with the licensed applicant. So the antitrust consent decree also designates a court in the Southern District of New York as the rate court for ASCAP. Notably, despite the wide-ranging developments in the music business since 1941, the antitrust consent decree has only been amended twice. You may read more about ASCAP's consent decree in the Southern District of New York's decision in the 2004 case of United States versus ASCAP. So the 1941 DOJ antitrust action also resulted in a consent decree with BMI. However, BMI now operates under a, quote, new 1966 consent decree. BMI's consent decree involves many of the same provisions as the ASCAP consent decree, including a BMI rate court in the Southern District of New York as well. So, what is the real takeaway from these consent decrees? In essence, the consent decrees seek to prevent the anti-competitive exercise of market power while preserving the transformative benefits of blanket licensing. The Supreme Court has maintained that industry participants have benefited from the, quote, unplanned, rapid, and indemnified access to the vast repertoires of songs that each PRO's blanket licenses make available. So in the midst of the proliferation of streaming and music services, ASCAP and BMI took their case to the DOJ in 2014 in order to significantly modify royalty rates in the new age of musical works. The discrepancy in musical work royalties, so-called performance income, and sound recording royalties is substantial. Currently, in the context of digital music, the rates set for musical work royalties are about 1/12 of the rates for sound recordings. You may read more about this in the U.S. Copyright Office's 2015 publication entitled Copyright in the Music Marketplace. PROs and major publishers use that 1/12 statistic to demonstrate that ASCAP and BMI's rate courts continue to produce below market rates for musical works. In addition to restructuring the anti-competitive protection of the consent decrees, ASCAP and BMI also asked the DOJ to change the licensing model for musical works. Specifically, ASCAP and BMI requested that the DOJ move away from 100% licensing and towards fractional licensing. The 100% licensing model grants a songwriter with any ownership on a song, even as little as 1%, the right to license the entire song on behalf of all other songwriters. Furthermore, that same song can be only licensed once. Now, fractional licensing requires a license from every other owner of a song. And since the average song has several owners, fractional licensing would require businesses to license millions of the same rights multiple times over. So BMI explains the implications of the DOJ's 100% licensing method as follows. If the BMI consent decree were modified to reflect the DOJ's interpretation, a BMI songwriter would be impacted both creatively and financially if he or she collaborates and co-writes a song with an ASCAP writer. In a 100% licensing world, if a music user decides to license a BMI songwriter's co-written song from ASCAP and not BMI, the following may likely occur. 1. ASCAP could license a songwriter's co-written works at ASCAP's own rate, not BMI's rate. 2. ASCAP could reduce a songwriter's payments by its own overhead and even before it enters BMI's distribution system. 3. The songwriter could be subject to ASCAP's distribution methodology, not BMI's methodology. And 4. The songwriter's distributions could be delayed. As such, BMI explains that if the DOJ's interpretations were put into action in order to avoid the 4 problems outlined above and to ensure that only BMI licenses the songwriter's share in co-written works, the songwriter would have to collaborate only with other BMI writers. Even then, however, there would be no guarantee that other songwriters would remain at BMI. As such, the songwriter's choice of collaborator would no longer be determined by choosing the best writer for the job, but instead by the co-writer's PRO affiliation. Again, this is BMI's very own explanation of the implications of the DOJ's 100% licensing method. So I think you can tell what method songwriters prefer and what method businesses prefer. If you don't know, I'm either a very bad teacher or just a good poker player. At this time, before we jump into the depths of the current protracted battle between the DOJ, ASCAP, and BMI, let's spend some quality time examining music publishing and recording rights a little bit more thoroughly. This examination comes with a bit of mathematics, so I apologize in advance for any PTSD you may experience that is associated with your high school or college calculus course. So let's start with an overview of the record business. After many years of consolidation, there are only 3 major distributors left, and they are all owned by the major labels' parent companies. They are Sony, which includes Columbia, Epic, and RCA Records; Universal, which includes Universal Republic, Interscope, Capitol, Island, and Def Jam; and WEA, which includes Warner Brothers, Electrica, and Atlantic. So, what is a record? The contractual definition of a record in nearly every record agreement includes both audio-only and audio-visual devices, such as a DVD. The definition of a record also includes any other device now or hereafter known that is capable of transmitting sound alone, or sound with visual images. Most deals define records to mean any kind of delivery of your performance for consumer use, whether sound alone or with visuals. An original recording in a studio is a, quote, master. It is called a master because it is the master from which all copies are made. Masters were previously on high-quality tape, but now masters are done on computer hard drives. Moreover, the master recordings are multi-track, meaning that each instrument and voice is recording on a separate track. When the recording is finished, the master is edited, mixed, and equalized. Then, the mixed multi-track is reduced down to a 2-track stereophonic master, which is ready for the duplication process. As such, there are 2 masters, the original multi-track and then the finished 2-track. So the division of proceeds between the artist and the record company works as follows. The artist royalty is a percentage of the wholesale price. Record companies sometimes call this price the published price to dealer, or PPD, or outside the United States, the base price to dealers, or BPD. Each royalty percentage is known as a point, so if an artist has a 10% royalty, that artist has 10 points. Thus, the artist may multiply his or her royalty percentage by the wholesale price to calculate revenue. For example, a wholesale price of $10 multiplied by a royalty rate of 10% equals a royalty of $1. So typically, a record company pays an artist in advance for signing with the record company. This advance is paid against collected royalties. It works as follows. The record company pays a sum of money to keep the artist, the advance, and then keeps the artist's royalties until it recoups the advance. After the advance is fully recouped by the record label, then the artist begins to collect on his or her royalties. An artist's royalty in a record agreement is really based on that artist's clout. A quote, new artist is someone with a minor social media presence who has never sold more than about 100,000 albums per release. A mid-level artist is either an artist whose last album sold in the 200,000 to 400,000 range, or a new artist with a ton of social media buzz, millions of streams, and a substantial touring base. A superstar is an artist who has millions of sales from upwards of 750,000, a massive social media presence, and millions of Spotify streams. With the aforesaid categories in mind, the range of royalties is as follows. A new artist, which is 13% to 16% of PPD, mid-level, which is 15% to 18% of PPD, and a superstar, which is 18% to 20% or more of PPD. This begs the question, how much do these royalties mean in real money? Most top-line CDs sell for a wholesale price of $8.50 to $10 or more. The wholesale price of digital downloads is 70% of the retail price. So to calculate his or her royalties, the artist multiplies his or her royalty rate by these numbers. For example, if an artist has a 15% royalty and the average wholesale price of the artist's album is $9, the royalty paid to the artist is $1.35. However, the rate for an artist's single is normally 3/4 of the album rate and tops out between 10% and 14%. This is because record companies make less profit on singles. Because consumers mostly stream their favorite songs, streaming royalties are important to understand. Streaming royalties are based on an artist's royalty percentage multiplied by the record company's receipts attributable to that artist's streams. Thus, if an artist's streams earn the company $100 and the artist has a 15% royalty, the artist gets 15%. Next, here's a shocker to many unfamiliar with the music recording business. Most record deals do not require the company to make a record. Notably, almost all contracts contain a clause that allows the record company, instead of recording the album, to pay the artist a sum of money equal to minimum union scale for an album, or either the difference between the recording fund and the cost of the last album. This is called a pay or play provision, which, as the name suggests, means that the record company has the option of either playing your music or paying you off. Now, with the basics of the record business in mind, let's move to the publishing side of the music industry. Before diving into the specifics, I'd like to offer you a quick background of copyright law as it pertains to the music industry. After obtaining a copyright, the artist receives the following exclusive rights. First, the right to reproduce the work. Second, the right to redistribute copies of the work. 3, the right to perform the work publicly. 4, the right to make a derivative work. And 5, the right to display the work publicly. However, there are 5 major exceptions to the artist's exclusive rights in his or her copyright. These are known as compulsory licenses. The 5 forms of compulsory licenses are 1, cable television rebroadcast. Here, the cable television compulsory license requires the broadcasting stations to allow the cable company to retransmit their signals in exchange for a payment of set fees. 2, public broadcasting system. Here, PBS requires copyright owners to license their work at low rates. 3, jukeboxes. Here, they must pay a set license fee. 4, digital performance of records. This was added in 1995 and modified in 1998, which requires owners of recordings to allow the performances of masters on digital radio. And 5, phonorecords of digital downloads of non-dramatic musical compositions. This is called a compulsory mechanical license. See, I told you I would revisit this topic at this time. The 5th category, compulsory mechanical license. This one is critical. Inherent in a compulsory mechanical license is the concept of mechanical royalties. Mechanical royalties are the monies paid to copyright owners of the manufacture and distribution of records. You can find the compulsory license for records in Section 115 of the Copyright Act. In sum, it states that once a song has been recorded and released to the public, the copyright owner must license it to anyone that wants to use it in a phonorecord, and 2, for a specific payment established by the law. The current statutory mechanical royalty rate for physical recordings, such as CDs and permanent digital downloads, is 9.1 cents for recordings of a song 5 minutes or less, and 1.75 cents per minute or fraction thereof for those over 5 minutes. However, the owner is only required to issue a compulsory license if all of the following conditions are present. 1, the song is a non-dramatic musical work, and 2, it has been previously recorded, and 3, the previous recording has been distributed publicly in phonorecords, and 4, the new recording does not change the basic melody or fundamental character of the song, and 5, the new recording is only used in phonorecords. So with these music copyright fundamentals in mind, we now turn to an overview of the music publishing business before we examine the ongoing DOJ battle. When a publisher makes a publishing deal with a songwriter, it takes on the obligation to find users, issue licenses, collect the money, and pay the writer. Thus, the publisher, quote, administers the songwriter's compositions. Traditionally, the publisher splits all income 50-50 with the writer. So we are almost back to the present-day DOJ litigation, but before we get there, I'd like to examine the controlled compositions clause in record deals. A controlled composition is a song that is written, owned, or controlled by the artist, in whole or in part. In recording agreements, the controlled composition clause is very critical, and it is typically defined to include any song in which the artist has an income or other owner interest, as well as any compositions owned or controlled by the producer of the recordings. The controlled compositions clause places a limit on how much the record company has to pay for each controlled composition. Unlike artist royalties, record companies do not recoup advances or recording costs from mechanicals. As such, record companies are very reluctant about paying much for controlled composition. So PROs like ASCAP, BMI, and even the for-profit PROs, namely CSAC and GMR, fit into the publishing side of the music industry. They basically work with the publishers by obtaining the right to license performing rights in the publisher's entire catalog of songs. The PROs then connect with radio stations, TV stations, and concert halls to make a deal that allow them to use all the songs of all the publishers that the PROs represent. PROs collect the fees, divide them up, and send the publisher a share. That's pretty much how they work. PROs monitor and allocate the license proceeds through the following categories. First is radio. Here, ASCAP and BMI use media monitoring companies to track radio stations across the United States. 2, television. Here, TV stations are required to keep cue sheets, which are listed on every composition used, how long it was played, and how it was used. 3rd, digital. Here, service providers have precise data of what's been played, how often, and to how many people. 4, live events. Here, PROs pay based on domestic live performances, but it is only for the top 300 grossing tours as reported in a magazine called Polestar. PROs pay based on set lists, which the PROs get either from the venues or the artist management. PROs also track sports stadiums and arenas to pick up songs that everyone claps to. And 5, background music. Here, even music in grocery stores, elevators, and waiting rooms is logged separately. So the next time you're in a very awkward elevator situation, but a little jingle saves the day, you now know that some songwriter out there is making money from that elevator jingle that hopefully broke up that awkward interaction. Now that you have a more clear idea of publishing rights and recording rights in the music industry, we turn our attention back to the recent developments of the DOJ's battle against ASCAP and BMI. On August 4th, 2016, following over 2 years of review, the DOJ determined that the marketplace needed to preserve the protections afforded by consent decrees and opted not to change them. Moreover, the DOJ clarified that fractional licensing is not permitted under the consent decrees. I urge you to read the statement of the Department of Justice on the closing of the Antitrust Division's review of the ASCAP and BMI consent decrees. This is dated August 4, 2016, and it's available online. BMI and ASCAP challenged the ruling in BMI's rate court in the Southern District of New York, which has been more accommodating to the PRO's concerns than ASCAP's rate court. Next, on September 16, 2016, Federal Rate Court Judge Lewis Stanton issued an order rejecting the DOJ's recent interpretation of the antitrust consent decree with respect to BMI. Judge Stanton concluded that BMI and ASCAP are free to engage in the fractional licensing of musical works. Not surprisingly, on November 11, 2016, the DOJ filed a motion to appeal Judge Stanton's decision. The DOJ appealed to the Second Circuit, filing multiple requests for extension, the last of which was denied. So with battle lines drawn, the DOJ has loaded for bear with friendly firepower from tech firms like Google, Netflix, and iHeartMedia, among others. Oral arguments are expected to commence later this year or early in 2018. As such, in the midst of this protracted battle, many players in the music industry remain locked up in monopoly jail. As of 2017, in August, ASCAP filed an amicus brief in support of BMI, which is normally a competing performing rights organization. Most recently, on August 31st, 2017, the DOJ called BMI's bluff and almost completely turned BMI's legal strategy on its head. There's a particular paragraph on page 14 of the DOJ's brief that could send shockwaves to the music industry. I quote it as follows. The United States agrees with BMI that the decree does not prohibit BMI from offering fractional licenses in all contexts. In particular, the decree does not prohibit BMI from providing fractional licenses for songs that are outside the repertoire, as defined by the decree, and separate from the blanket license. Such licenses would be outside the auspices of the decree and thus not subject to its requirements or its protections. For example, the rate court could not determine the reasonableness of rates for fractional licenses, nor for any per program or blanket licenses that included fractional licenses. And if BMI engaged in collective licensing of fractional interests of songs outside the repertoire, the United States would have to determine whether to investigate that conduct, and if so, determine whether such collective licensing violates the antitrust laws. But that issue is not presented here. End quote. So this simple paragraph contains many important points that will likely have a huge impact on the music industry. First, the DOJ sends a not too subtle message that the consent decrees are beneficial to ASCAP and BMI by protecting them from antitrust laws. Notably, both ASCAP and BMI have complained of the perceived unfairness that they are under consent decrees, while other PROs like CSAC and GMR are not. This should ring the alarm for ASCAP and BMI to not advocate any policy in the future that does not include some form of compromise that protects them from the antitrust laws. Second, while it is now clear that ASCAP and BMI can engage in fractional licensing outside of the consent decree, the DOJ has just leveled the full force of the antitrust laws at ASCAP and BMI and asked them to try, if they feel lucky. ASCAP and BMI will find it hard to navigate these waters. They must find a way to efficiently license a potentially large number of fractional licenses without engaging in price fixing. Attempts to simplify pricing into something like a blanket license will surely get them in trouble, as will any attempts to establish a pricing scheme that does not permit licensees to make choices between competing composers or licensors to undercut rival songs to encourage airtime. So even if they meet these basic requirements, there are still plenty of opportunities for ASCAP and BMI to get into a lot of trouble. So now, as the monopoly battle rears its head in the music industry, there are several bail bondsmen that offer sureties to collect the pitfalls of the contemporary music licensing system. The goal of these bail bondsmen, if they are truly going to extricate these music players from monopoly jail, must involve marketplace participation by musical work owners and licensees in which sound recording royalties are considered in musical work proceedings. That really is the key. The bail bondsmen in this case are 1. The Copyright Royalty Board, or CRB, the Songwriter Equity Act, 3. The Fair Play, Fair Pay Act, and 4. The publishers. The aforesaid bail bondsmen seek to drive the players in the music industry out of monopoly jail and toward that much more preferable monopoly square, the community chest. The Copyright Office published a 2015 report that proposed a shift of rate-setting proceedings in the Southern District New York rate courts to the CRB. The CRB, the first bail bondsman, would become the arbiter in musical work rate-setting procedure, though the antiquated process would remain the same. Rate decisions under the CRB could, however, encourage marketplace participation by consolidating information into a single entity. Nevertheless, the CRB method is just too narrow-minded by itself. In 2014, Congress introduced the Songwriter Equity Act, our second bail bondsman. The essence of these proposed laws is to amend the portion of the Copyright Act, 17 U.S.C. Section 114I, that currently prohibits PRR rate courts from considering the rate media services paid for sound recordings public performance royalties when setting a reasonable rate for musical works. The proposed section, 114I, seeks to eliminate the prohibitory language and provide that it is the intent of Congress that royalties payable to copyright owners of musical works for the public performance of their works shall not be diminished in any respect as a result of the rights granted in Section 106.6. Thus, the Songwriter Equity Act would allow PRR rate courts to consider sound recording royalties as part of the formula when setting musical work royalty rates. If this bill passes along with the implementation of the CRB may be able to work with all parties, publishers, record labels, and licensees to develop a reasonable and more open marketplace. Next, the Fair Play, Fair Pay Act, the FPFP, could result in more drastic changes to the music licensing system. Currently, terrestrial radio stations manage to avoid paying royalties to artists and labels because such airplay is considered promotional, even though streaming services and broadcast television networks pay royalties to artists. I must note that sound recordings made after 1972 fall within the scope of federal copyright law, but there's uncertainty whether broadcasters have to pay to perform recordings made before 1972. You may remember that I discussed this issue with you earlier. Thus, proponents of the Fair Play, Fair Pay Act argue that it will make a clear statement that pre-1972 recordings have value, and those who are profiting from them must pay appropriate royalties for their use. This is a reference to the ongoing web of litigation involving recordings made when copyright was still a matter of state law. As previously mentioned, sound recordings made after 1972 are covered under federal copyright law. So as a result, the Fair Play, Fair Pay Act was introduced in the House of Representatives in 2015. In March 2017, a bipartisan group of legislators led by Representatives Jerry Nadler, a Democrat from New York, and Marsha Blackburn, a Republican from Tennessee, have reintroduced the Fair Play, Fair Pay Act, a bill that would establish a public performance right for sound recordings on terrestrial radio, and this would force stations to pay labels and artists. the Fair Play, Fair Pay Act extends a full public performance right to sound recordings based on the idea that sound recording owners should have a complete public performance right. Also, similar to the Songwriter Equity Act, the Fair Play, Fair Pay Act amends the language of Section 114I to permit the PRO rate courts to consider sound recording royalties in musical work proceedings. Again, this is the key. Now, it's time to turn our attention back to our favorite musical duo, Flo and Eddie. See, I promised you I would return to them in this program, and here we are. In June 2017, a settlement was reached in a class action lawsuit alleging SiriusXM Radio Inc. was performing, distributing, and reproducing pre-1972 recordings as part of its internet and satellite radio services. If you are an owner of one or more sound recordings fixed before February 15, 1972, that have been performed, distributed, reproduced, or otherwise exploited by SiriusXM without authorization to do so in the United States between August 1st, 2009 and November 14, 2006, you may be entitled to benefits from the SiriusXM class action settlement. So plaintiff Flo and Eddie Inc. filed the SiriusXM class action lawsuit on August 1, 2013 on behalf of itself and a class of owners of pre-1972 sound recordings. Flo and Eddie alleged that SiriusXM was performing, distributing, and reproducing those pre-1972 sound recordings as part of its satellite and internet radio services, even though it had no license or authorization to do so. The SiriusXM class action lawsuit alleged violation of California laws and asserted that SiriusXM was liable for conversion, misappropriation, and unfair competition. The plaintiffs sought damages, restitution, and injunctive relief. The case then proceeded to trial, and on September 22, 2014, the court found SiriusXM liable. However, the parties subsequently agreed to settle the litigation. SiriusXM denied any wrongdoing and maintains that no state law provides owners of pre-1972 sound recordings a right to control the performances of those recordings. However, SiriusXM has agreed to settle the sound recording class action lawsuit to avoid the burden and expense of ongoing litigation. The SiriusXM class action settlement was granted final approval on May 8, 2017, and the effective date is June 5th, 2017. So wake up! You may be an eligible class member, though you're probably not. I'm just testing to see if you're still listening. Class members of the SiriusXM settlement include anyone who owns one or more pre-1972 recordings that were performed, distributed, reproduced, or otherwise exploited by SiriusXM without a license or authorization to do so from August 1, 2009 through November 14, 2016. Class members are eligible to receive a share of the $25 million settlement fund and a royalty rate of up to 3.5% on future performances for a period of 10 years. This payment account may change depending on the outcome of certain appeals by SiriusXM. So we go back to the merits of the Fair Play, Fair Pay Act. As of June 2017, the Fair Play, Fair Pay Act has added 15 more bipartisan sponsors since its reintroduction on March 30th, 2017. The bill now has the support of 21 House members who support radio stations paying artists and labels for airplay. Curiously, the United States is the only major country in the world that does not pay such royalties. The Fair Play, Fair Pay Act is adamantly opposed by the National Association of Broadcasters, which over the decades has managed to beat back these past efforts. So while the Fair Play, Fair Pay bill stipulates that the U.S. rate be determined by the rate court, the performing rights organizations, PROs like ASCAP and BMI, collect for publishers and songwriters an estimated 3 to 5% annually from radio stations. And this is based on a complex revenue formula that takes into account everything from tower watts to the number of listeners. Revenues for the U.S. over-the-air radio market was $14.1 billion in 2016, according to investment analyst BIA Kelsey. Thus, assuming half of those are talk or news format, even a conservative estimate of 3% would put potential artists and label earnings above $200 million. So, with all that in mind, let's turn our attention back to the consent decrees. Over time, music publishers have pushed to amend the PRO antitrust consent decrees while withdrawing new media rights. Recently, some publishers have even done direct deals with digital service providers such as Pandora and Spotify. Notably, in 2011, EMI Music Publishing, which later merged with Sony ATV to become the largest music publisher in the United States, was the first of the major publishers to eliminate ASCAP and BMI's right to license its songs to certain new media services in order to gain leverage in direct license negotiations. If publishers choose the all-out option and withdraw from PROs, a couple $100 million in revenue could flow into the music industry that ASCAP and BMI otherwise collect as overhead and expenses. You may read the most updated ASCAP and BMI annual reports on their respective websites. Notably, ASCAP and BMI collected record high revenues of $1.059 billion in 2016 and distributed more than $918 million to its songwriter, composer, and music publisher members. However, though distributions were up 5.6% over the prior year, there are still hundreds of millions of dollars in revenue that are otherwise allocated to BMI and ASCAP's overhead and expenses. As you may recall, ASCAP and BMI are not-for-profit entities. So on the flip side of the monopoly board lies the for-profit PROs, which are CSAC and GMR. See, I promised you I would talk more about CSAC and GMR in more detail. In April 2017, BMI lost a deal to rival PRO, CSAC. Established in 1930, CSAC in 2016 bought the Harry Fox Agency, which I mentioned earlier collects mechanical fees, and was itself acquired by Blackstone Core Equity Partners earlier in 2017 in what was reported to be a deal worth $1 billion. Annually, CSAC collects more than $250 million on behalf of its roster of 400,000 songs and 30,000 affiliated songwriters, composers, and music publishers. Adele joins Bob Dylan, Neil Diamond, among others, on the CSAC roster, which reports to be a smaller, more effective, and nimble PRO, as compared to ASCAP and BMI. Moreover, as I explained earlier, CSAC is not bound by the consent decrees because it is a for-profit entity. Another difference is that CSAC pays a royalties based on monthly rather than quarterly, and is also able to offer singular licenses that aggregate both performance and mechanical rights. CSAC is making even more powerful moves. In July 2017, CSAC completed its first-rate arbitration with the Radio Music Licensing Committee, which has resulted in CSAC touting its success in increasing its rate relative to its market share, even though its fees were lowered in aggregate as a result of the proceeding. The arbitration panel awarded CSAC a fee of 0.2557% of radio station net advertising revenue, based on the fact that CSAC had only about 1/10 of the market share of the industry's dominant player, ASCAP, at the time of the computation, about 4% to ASCAP's 45 to 50%, adjusted for CSAC's market share. ASCAP's actual fee of 1.73% would be 0.173% of station net revenue. By that calculation, CSAC is proclaiming an arbitrated rate approximately 50% higher than the radio industry rates commanded by ASCAP. BMI receives roughly the same 1.73% rate, and the two control market share of some 85%. So GMR, the other more boutique for-profit PRO, is in the midst of its own battle against the Radio Music Licensing Committee. GMR was launched 3 years ago by Eagles manager Irving Azoff. GMR represents the rights of approximately 75 songwriters. GMI filed its own antitrust complaint against the Radio Music Licensing Committee in December 2016 in federal court in Los Angeles. In its suit, GMR alleges that the radio group acts as a cartel to suppress royalty rates. According to the complaint, GMR has been in negotiations with the Radio Music Licensing Committee since shortly after it was launched, but they have yet to reach a deal because GMR just simply will not agree to an industry-wide licensing deal and binding rate arbitration. So at issue is how to determine the market share for radio stations licensing songs by Benny Blanco, Bruno Mars, Drake, Pharrell Williams, Ryan Tedder, Boz Scaggs, Billy Idol, Eddie Vedder, John Lennon, John Bon Jovi, Smokey Robinson, and more. There's not much of a free market to go by since, as we discussed, the music industry's two biggest performing rights groups, ASCAP and BMI, operate under those consent decrees signed with the Department of Justice, which stipulate that if parties can't agree on rates, a rate trial before a federal court will make the determination. I discussed this at length with you a lot earlier. While the Radio Music Licensing Committee, which represents most of the biggest radio networks like iHeart, CBS, Cox Media and Intercom, EMIS and Cumulus, as well as independent stations, wants GMR to be regulated in what it can charge, GMI argues that it is legally free to charge what it likes as a relatively small organization. Thus, GMR is pushing for a free market of music, whereas ASCAP and BMI remain stuck on the monopoly board due to the consent decrees they agreed to decades ago in order to keep their business model alive today. Now, back to our regularly scheduled programming involving our favorite cast of monopoly pieces, ASCAP, BMI, and the DOJ. In a groundbreaking show of unity, and probably in light of the ongoing DOJ battle, ASCAP and BMI announced in July 2017 that they will create a single, comprehensive database of musical works from their combined repertoires that will deliver an authoritative view of ownership shares in the vast majority of music licensed in the United States. Expected to launch in the fourth quarter of 2018, the database will feature aggregated song ownership data from ASCAP and BMI and offer greater transparency to music users and the industry as a whole. According to a release, a team of copyright, technical, and data experts from the two organizations began working on the project over a year ago in anticipation of the demand from licensees in the industry for more clarity around ownership shares. The database, which will be publicly available initially via the two organizations' searchable repertoire databases, ASCAP's ACE repertoire and BMI's repertoire search, will feature aggregated information from those repertoires and will indicate where other performing rights organizations may have an interest in a musical work. The joint database will serve as a foundation that can evolve to include a broader range of music information across the entire industry. So, the two organizations will continue to maintain their own websites, but users will see the combined database when they search for information on titles. Ultimately, the move is a welcome one to virtually anyone seeking songwriting and publishing data, which really for decades has involved often laborious digging and combining of information from different sources. So while ASCAP and BMI work together frequently on common interest matters such as the ongoing battle with the DOJ over song licensing, the two organizations are really traditionally competitors and often fierce rivals. Thus, this database initiative is unprecedented in its level of scale and cooperation. The two organizations are also the two best entities to host it. The U.S. Copyright Office was also considered, as they are constantly updating and refining their data for accuracy, and they really do have strong market-driven reasons to do so. So ASCAP and BMI's respective teams are analyzing, testing, and reconciling the data from each organization, addressing incomplete and or incorrect registrations, share splits, U.S. representation of international works, and complicated ownership disputes, among other things. The joint database will roll out in phases, with Phase 1 expected to launch approximately by the end of 2018 and include the majority of ASCAP and BMI registered songs. Future phases will explore customizable, interactive API solutions and the potential inclusion of other databases. Both organizations' public databases include the following information, which will be combined into this joint database. 1. Song and artist composition titles. 2. Performing artist information. 3. Aggregated shares by society for ASCAP and BMI. 4. International standard work codes and other unique identifiers. And 5. IP names and numbers. Despite ASCAP and BMI's collective efforts, however, Publishers may decide to withdraw from PROs just to create a more lucrative free market. If publishers decide to do so, the DOJ may lift the age-old consent decrees, thereby generating more revenue streams for producers, publishers, and songwriters. Should publishers withdraw from PROs, and all of these players in the music industry may get out of jail and move on to the coveted community chest that lies ahead. That's ultimately where the music industry wants to go. Put simply, the fragmented history of PROs and copyright law in the United States caused the piecemeal changes in a rapidly evolving music industry that ultimately developed into a game of monopoly. Now, all of the players in the music industry's game of monopoly, ironically spawned by consent decrees aimed at preventing a small M monopoly, want to advance to go and collect their $200, but it's really not that easy. The transaction costs that sit in the community chest must undergo reform in order to reduce the overhead associated with participation in the music industry licensing game. Owners and licensees must work more creatively in the marketplace and not sit behind the facade of outdated consent decrees. So, whether the PRO rate courts remain the arbiters or the CRB assumes that role, sound recording royalties must be considered in musical work proceedings. That really is the key. As if there are not enough layers to this topic, the legal battle is further complicated by the fact that the DOJ leadership changed when the Trump administration took office. Makan Del-Rahim is now the DOJ antitrust chief. While the general feeling among songwriters is that the Republican administration is stronger on copyright protections than the Democrats, it is still unclear whether that goodwill is something that's going to spill over to this battle. We'll have to stay tuned on that one. Now it's time to turn back the clock to your favorite course in your first year of law school, constitutional law. The constitutional law argument in this case is very creative and only adds to the looming overhaul of the music industry's intellectual property bureaucracy. On September 13, 2017, the Songwriters of North America, also called SONA, sued the DOJ over the 100% licensing issue. They cited the Fifth Amendment takings clause, and they argue that forcing songwriting partners to relinquish their claim on a song was an illegal taking of property. That suit is currently ongoing. I'd like to explain a bit more about SONA. SONA is a grassroots advocacy organization. It was founded in January 2015 by songwriting partners Michelle Lewis and Kay Hanley in response to the low licensing rates being paid to songwriters by music streaming services. SONA sued for a violation of their members' Fifth Amendment right not to be deprived of their property without due process of law. The lawsuit was filed in the United States District Court for the District of Columbia, also known as the DDC. SONA argues that the 100% licensing mandate diminishes and encumbers the copyright interests and private contractual rights of songwriters and composers. SONA argues that this property was taken by a method that violates SONA members' procedural and substantive due process rights and is a taking of their property without just compensation from the government or a third party. In addition, SONA sued for a violation of administrative law, specifically the Administrative Procedure Act, or the APA. Among other requirements, the APA precludes federal agencies from making rules or policies that are adopted without appropriate procedural safeguards, or are arbitrary, capricious, and abuse of discretion, otherwise unlawful, or unsupported by facts in the public record. The APA also prohibits federal agencies from exceeding their respective authority. SONA claims that 75% of songwriters' income is regulated by the federal U.S. government, and that the consent decrees, which, as we discussed at length earlier, date back to 1941, and that ASCAP and BMI operate under, unfairly restrict the performing rights organizations and were imposed because of antitrust concerns that honestly are no longer relevant. In sum, SONA is asking the United States District Court for the District of Columbia for 4 specific results. 1, declare the 100% licensing mandate unconstitutional under the Fifth Amendment. 2, declare the 100% licensing mandate unlawful by the APA. 3, an order preventing the Department of Justice from enforcing or enabling the 100% licensing mandate. And 4, any other relief or results that the court determines is appropriate. That last request is my personal favorite catch-all. However, here's the catch as I see it. ASCAP and BMI's business models are only relevant because of the consent decrees. As such, the music industry is really trapped in this game of monopoly because the major PROs, ASCAP and BMI, function solely because of the consent decrees. Now, these same consent decrees are currently no longer relevant, as Sona aptly stated. Thus, how can a monopoly operate without a consent decree? The federal government will not just remove the consent decree while allowing ASCAP and BMI to maintain their monopoly. I just do not see that happening. As I explained above, the DOJ has broad discretion when enforcing consent decrees. Thus, ASCAP and BMI will need to restructure their respective business models outside the guise of not-for-profit entities so that they really force the DOJ's hand into modifying their consent decrees. So now, with all the history and recent developments behind us, what do actual singer and songwriter royalties look like today? A few real-life examples will help answer that question more clearly. This leads us to our first example. Rodney Jerkins, who alongside Andre Lindahl produced Justin Bieber's 2010 hit, As Long As You Love Me, disclosed their royalties from that song in front of an audience of fellow songwriters and publishers in Los Angeles during September 2017 before a panel at the Recording Academy. Rodney Jerkins detailed how he partnered with a blossoming songwriter from Norway, Andre Lindahl, who eventually ended up penning a hit for Justin Bieber. Lindahl had 20% of the publishing rights when the song came out in 2010. According to Jerkins, by 2013, the song earned total revenue of $146,000 through BMI. Jerkins broke down the royalty figures as follows: $53,000 from 347,827 radio spins, and $7,065 from 1,509 exposures on SiriusXM. Here's the crazy part. More than 30 million Pandora plays earned the songwriter just $278, while in excess of 34 million YouTube streams generated a mere $218. As Jerkins stated, if he owned 100% on YouTube, he would have made just 1,100, and on Pandora, 1,400. It's pretty crazy, right? Those figures demonstrate the urgency behind reconfiguring copyright law in the rapidly changing music industry. So we turn to another real-life example. A band, which shall remain anonymous, provided the following Spotify payout for the time period of October 15, 2013 through February 15, 2013. With a total number of streams in the amount of 1,023,501, the total revenue collected was just $4,955.90. That's an average per stream payout of 0.004891. That's just fractions of the penny. It's ridiculous. And here's one last example. Aloe Blacc penned an article about his songwriter royalties on Avicii's release Wake Me Up, which he co-wrote and performed. Wake Me Up was the most streamed song in Spotify history at the time, and the 13th most played song on Pandora since its release in 2013, with more than 168 million streams in the US. That yielded only $12,359 in Pandora domestic royalties, which were then split amongst the songwriters and their publishers. Thus, in return, Aloe Blacc has earned less than $4,000 domestically at the time of his article in 2014. Again, these numbers are just too low. Thus, be on the lookout for higher payouts, hopefully, to artists and songwriters in the near future as the DOJ battle continues to unfold. As I mentioned earlier, something just has to give. ASCAP and BMI either have to restructure their respective business models, which they appear to be doing by combining a single comprehensive database of musical works from their combined repertoires, or the DOJ needs to make moves towards fractional licensing and modify the outdated consent decrees. Ultimately, ASCAP, BMI, and the DOJ are control of the fate of the future profitability of songwriters in the music industry. Now, I hate to paint the music industry on an apocalyptic canvas because it is a fascinating industry filled with so many creative people and lots of quality content. Thus, I hope this program was energizing and not draining. Most importantly, we are on the brink of a transformative time in music. So I hope the information you have gained from this program has provided you with a solid foundation to understand the dynamic game of Monopoly that started decades ago. So I'd like to end this program on the proverbial high note, though I promise I will not sing. Streaming is the modern day radio. It really is. In the same way that radio created a preliminary challenge to monetizing music, streaming has created a similar challenge. However, like radio decades ago, streaming has the potential to make the music industry bigger than it's ever been before. You can now access a virtual record store through services like Spotify, Apple Music, and Pandora, for example. Artists can now broadcast their music to millions of consumers in ways that were otherwise impossible a mere 7 to 10 years ago. The streaming numbers are very high, so the challenge really is to fairly compensate singers and songwriters for their coveted intellectual property. Ultimately, the outcome of the DOJ's battle against ASCAP and BMI will set the stage for what's next in the music industry's game of Monopoly. So stay tuned, and thanks for watching.